So we have an important update in a critical rifle and magazine ban challenge that is currently up for review. The Trump administration just stepped up and joined to argue that the state of Illinois' ban does violate the Second Amendment and is unconstitutional. This is great news. It's a huge development in this case, so let's break down what just happened and what this means going forward. Now, before we jump into this video, if you want to support the channel for free, please consider subscribing to the channel. That of course helps the channel to grow. And then also, if you want to support me on other platforms, I will leave a link down below to the podcast where you can get the audio form of these videos, and then also the podcast that I do over on the Liberty Lounge podcast. Check those out using the link down below. That's another way you can support what I do. As I mentioned in the intro, we have some great news in a critical challenge against the state of Illinois and their ban that they put in place against so-called assault weapons and their magazine restrictions as well. The Trump administration just stepped up to file a brief in this case, and they argue that the rifle and magazine bans, along with other restrictions in PICA, are also a violation of the Second Amendment and they need to be struck down. Currently, the state of Illinois has appealed these cases up to the 7th Circuit, and once again, they're asking for the 7th Circuit to side with them and ultimately reverse a decision that was issued by Judge McGlynn, which was a pro-2A decision striking down PICA entirely. The Trump administration's brief argues that Judge McGlynn got the decision correct and that it should be allowed to stand, and that the 7th Circuit should find that these rifle and magazine bans, along with other, arms bans, are in fact unconstitutional. Now, you might remember that originally in multiple cases, a district court judge, Judge McGlynn, issued preliminary injunctions that were intended to halt the enforcement of PICA. However, the state of Illinois then appealed those preliminary injunctions up to the 7th Circuit, who of course upheld those bans, which then ultimately led these cases to go to the Supreme Court on an emergency basis. They wanted the Supreme Court to step in at an interlocutory, in-between kind of emergency basis and strike down what was going on in the state of Illinois, at least temporarily. But the Supreme Court ultimately denied emergency review to those Illinois cases. However, even in the denial, you had Justice Thomas, who stated that if the 7th Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the case reaches a final judgment. The court must not permit the 7th Circuit to relegate the Second Amendment to a second-class right. Now, while all of that was happening, you still had the lower court judge, Judge McGlynn, who was moving the cases to a final merits decision, and ultimately he did rule on the merits of these cases. On review, Judge McGlynn once again found correctly that PICA is unconstitutional and must be struck down. But of course, Illinois then appealed once again to the 7th Circuit, and that's where we currently stand. However, things just got really interesting and kind of heated up in this case because the Trump administration now stepped in and they're arguing against PICA. This is great news because you have the United States government stepping in to argue against a state that put in place a categorical ban on these arms. In this recent brief, the United States government and the Trump administration argues that 3 years ago, the Supreme Court issued a landmark decision meant to break a habit developed by some states of treating the Second Amendment as a second-class right, subject to an entirely different body of rules than the other constitutional rights. Regrettably, not every state got that message. Just a few months after Bruin, Illinois outlawed some of the most commonly used rifles and magazines in America via a so-called assault weapon ban. In doing so, Illinois violated the Supreme Court's clear directive that states cannot prohibit arms that are in common use by law-abiding citizens for lawful purposes. In an earlier appeal reviewing a preliminary injunction against PICA, this court, the 7th Circuit, held that the act was likely constitutional and reversed, but this court made it crystal clear that its opinion was just a preliminary look at the subject. Now, after final judgment, there are 3 very good reasons why this court should reverse course and affirm the district court's injunction. First, as explained below, key aspects of Bevis's analysis are wrong, even judged against the Supreme Court's Second Amendment case law that existed at that time. Second, multiple Supreme Court justices, including Bruin's author Thomas, have since made it clear that they disagree with Bevis and other recent lower court opinions, and that the court is likely to grant certiorari in the next term or two to address the errors in those opinions. Third, after the court's decision in Bevis, the district court held a multi-day bench trial, heard significant evidence regarding the issue in this case, and made factual findings that show that the act violates the Second Amendment as applied to semi-automatic firearms and attachments that are in common use by law-abiding citizens for lawful purposes. Again, really powerful arguments coming directly from the Trump administration and the federal government against this state ban on rifles and magazines. Now, when arguing further on in the brief, the United States government states that in this case, the key question under the Second Amendment's text is whether the banned semi-automatic firearms are arms. Many of them, including AR-15s, are. So there you have them acknowledging that AR-15s and similar rifles are protected arms. Then they go on to point to the Supreme Court's recent decision in the Smith & Wesson PLCAA case, which just came out, this last month. And they point directly to not just Justice Kagan herself, but also Thomas, who acknowledged that AR-15s are in common use for lawful purposes. They also point out that the AR-15s in question are not uniquely dangerous and should not be treated any different really than any other semi-automatic handgun that the Supreme Court and other courts have said are clearly protected. They state that there is no meaningful distinction between semi-automatic handguns and semi-automatic rifles, and it would thus strain logic and common sense to conclude that the Second Amendment protects handguns, but not rifles. They then move on to point out how the militaristic weapon test that was used by the Seventh Circuit is improper and does not align with what the Second Amendment says, what the text of the Second Amendment actually outlines, or what the Supreme Court has said in their precedent. They point out that the text of the Second Amendment does not support that analysis, nor does the history or tradition of our nation. In fact, the history and tradition of our nation in the Second Amendment points to the direct contrary. Americans were expected to provide their own firearms for service in the militia, and that would mean that they were also required to possess weapons that would be most useful, not just for other purposes like self-defense, but also military use. Now, when it comes to magazines, they argue that PICA violates the Second Amendment, of course, pretty much in line with what they're arguing also against rifles. They state that as this court has recognized in the past, the Second Amendment protects and extends to certain important corollaries of the core right to possess arms for self-defense and other lawful reasons. Several such corollaries receive Second Amendment protections. The right to keep arms necessarily involves the right to purchase them, to keep them in a state of efficiency for use, and to purchase and provide ammunition suitable for such arms, and to keep them in repair. The right to keep and bear arms also involves the right to maintain proficiency in firearms use, and it involves the right to possess ammunition. Now, in this long description of other corollaries which are protected, they cite to a critical case, which is the Ezell versus the City of Chicago case. I'm probably butchering the last name. I'm sorry, Rhonda, but this again, shout out to Rhonda because she's a great 2A advocate who's helped not just to get a strong win in the Seventh Circuit to protect your right to train, but also again created strong precedent in the Seventh Circuit that I believe will help to strike down PICA in the Seventh Circuit, or at least be pointed to by the Supreme Court once it gets there. The Trump administration argues that although these activities may not literally involve the keeping of arms, each is a fundamental component of the right protected by the Second Amendment. Applying that principle to the act, the Second Amendment protects firearms attachments that are useful to the exercise of the right, including magazines, suppressors, and other firearms attachments that are in common use by law-abiding citizens for lawful reasons. Here you also see them point to how suppressor bans and other attachment bans are unconstitutional and that they should be struck down. And here they also point to what they argued recently in the Fifth Circuit in the U.S. versus Peterson case, which is challenging, suppressor restrictions under the NFA. Now, there's a lot more that's going on in this brief, but that should give you a good idea in a general overview of some of the strong 2A stances that were taken by the Trump administration against this PICA, ban that's going on against the rifle and magazine bans. And I have no doubt that maybe we'll see similar briefs pop up in other cases in other circuit courts, maybe like the Ninth Circuit in the Miller case, which is challenging California's ban on rifles as well. Regardless, I will note that this case is still in the Seventh Circuit. The Seventh Circuit has controlled this case. And if you're going to ask my opinion, I don't think that they're going to change much. Maybe it's going to be more of the same. So if the Seventh Circuit continues to defy the Supreme Court, this could be the challenge that they end up taking, especially since the Trump administration has now jumped in and are backing the challenge against the Illinois PICA bans. So again, great news that you have the Trump administration jumping in support of striking down PICA and the rifle bans and magazine bans and all the other restrictions. Ultimately, we're going to see how this plays out. So that's what's going on in the Illinois PICA challenges. That's what just happened. As we get more information, as it develops, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.